All right, welcome everyone to the continuation of yesterday's Judiciary Committee hearing. We'll pick up where we left off yesterday. 2-minute limit on testimony. If we crash majorly, we'll go ahead and roll over till Monday at 10 o'clock to finish up whatever we have left. And the first bill up today is HB 399. This is a request for an additional district court judge in the First Circuit. Which was funded in 2023, but the position wasn't created at the time. First up on 399 is Melanie May or Michelle Acosta for the judiciary. In support, Sonny Gannon for the Office of Public Defender. In support, Mark Murakami for Hawaii State Bar Association. In support, Marvin Dang, Hawaii Financial Services Association. In support, and Frank Schultz also in support. That's everybody who signed up on HB 399. Oh, I'm sorry. Are you here for 399?
Yes, my name is Jessica Orr. I'm the district court staff attorney, and you have our testimony. I'm just here for any questions.
Okay, great. Thank you.
Thank you.
That's everybody who signed up for HB 399. Anyone else wish to testify in 399? Okay, seeing none. Members, questions? I don't have any either. Let's go ahead and move on to HB 560. This appropriates funds to the judiciary for services contracted with community-based organizations that deliver essential services, streamline judicial processes, and support the judiciary's capacity to effectively meet the needs of vulnerable households. First up on HB 560 is Rodney Miley for the administrator of the courts. In support, next is Director Imani for Department of Human Services, also in support. Judith Clark for Hawaii Youth Services Network. In support, Alan Johnson for HSAC Hawaii Substance Abuse Coalition. In support, Kat Brady for Community Alliance on Prisons. In support, Angelina Mercado, Coalition Against Domestic Violence. In support, Trisha Kajimura for Parents and Children Together. Good morning.
Good morning, Chair, Vice Chair, and committee members. Trisha Kajimura here for Parents and Children Together, or PAC. Thank you for the opportunity to testify in strong support of this bill. We're a member of the True Cost Coalition. Judiciary funding for PACT allows us to provide services in the area of domestic violence intervention and prevention. We serve survivors and their children, child witnesses, and offenders in 3 counties. So we're a statewide social services organization, and as you know, the issue for true cost is that the gap between what our state contracts pay for and the actual cost or true cost of our services has grown quite wide over the years. We're more than willing to fundraise to make up the gap. In our case, for these particular services, it makes up our grant and aid application for this year for operating funds, but that gap is growing to be insurmountable, and we're risking not being able to meet the needs of the community with significant obstacles for funding in our future, such as what's happening at the federal level and also the skyrocketing cost of insurance. This is a significant concern for us, and we're asking for your help. Thank you.
Okay, thank you very much. Next up is Julie Mitchell for Ku'ikahi Mediation Center. In support, Rachel Figueroa, Volunteer Legal Services Hawaii. In support, Noreen Cole for Hawaii Children's Action Network Speaks on Zoom, perhaps.
Not available on Zoom, Chair.
Also in support, Renee Hamilton Cambiel for YWCA Kauai. In support, Nikos Leverance for Hawaii Health and Harm Reduction Center on Zoom, maybe.
Also not available on Zoom.
Also in support, Sandy Ma for the Legal Clinic. In support, Deborah Spencer Chun for Adult Friends for Youth. In support, Lori Long for Child and Family Service. Good morning.
Good morning, Chair, committee members. Child and Family Service will stand in strong support. I echo the comments made by the previous testifier, and we just thank you very much for hearing the bill. This will ensure consistent support for our most vulnerable residents. Thank you for the opportunity to testify.
Thank you. Next up is, I guess it's Micah Connie for Hawaii Community Foundation. In support, Michelle Bartel, Aloha United Way on Zoom.
Not available on Zoom, Chair.
Okay, thank you. She's in support. David Keith Kauila Copper for Legal Aid Society of Hawaii. Also in support, Melissa Pavlicek for Hawaii True Cost Coalition or her designee. Good morning.
Good morning, Chair, Vice Chair, and members of the committee. My name is Hannah Lisiak, and I'm here on behalf of the True Cost Coalition in strong support of HB 560. We stand on our written testimony in support, but just briefly, I wanted to emphasize that our coalition, which is comprised of over 70 community-based nonprofit organizations, provide crucial services for our most vulnerable populations. And the true cost of these services has increased far more dramatically than appropriations from contract increases have. So I want to thank you for hearing this measure, and I'm here for any questions. Thank you.
Thank you very much. Next is Monique Ibarra, Domestic Violence Action Center. In support, Penelope McKinsey in support, Carla Allison in support, Frank Schultz in support, Lori Ariel Tuchiki in support, Mihoko Ito on Zoom maybe,
Not available on Zoom, Chair.
also in support. Okay, that's everyone who's signed up on HB 560. Does anyone else wish to testify on HB 560 on Zoom or in person? Seeing none, members' questions? Okay, we'll move on to the next bill, HB 648. This establishes a 2-year pilot program in the probate court and family court of the First Circuit to fund certain guardianship and conservatorship related court resources in situations where the fund does not have sufficient funds to pay. First up on 648 is Jeanette Castagnetti for the state judiciary. In support, Roland Lee also for the judiciary. Oh, good morning.
Good morning, Chair, Vice Chair, members of this committee. My name is Roland Lee, Office of the Public Guardian Director. We support HB 648. Just have a couple of points to highlight. The first being that there's on page 1, line 17, would ask this committee just to amend the verbiage physician's letter to professional evaluations to make the bill consistent as it reads. Professional evaluations and physician's letters are not the same thing. Second part would be page 3, line 17. If we could just add in professional evaluations being functional evaluations, neurocognitive evaluations, or psychological evaluations, and that would probably assist with making the system better. The stakes are high in these guardianship cases. If a person is gets ordered under guardianship and they don't need it, there could be systemic harm done. And if a person is not ordered under guardianship, if a person is ordered under guardianship but doesn't need it, then there could be systemic harm done. But the way to fix it is really to make sure the evaluations are in place. And they're not the same thing as questionnaires either. Nothing further. If you have any questions, I'm here for to answer any questions you might have.
Okay, great.
Thank you.
Next up is Dainty Bartoldes for the Hawaii State Council on Developmental Disabilities. Good morning.
Offering comments. Specifically, we're here today in our capacity as the facilitators of a working group that was created by Representative Tarnas about a year and a half ago, 2 years ago. And I'm just here to speak in that capacity. I can answer any questions I know this measure came out of our working group, so I can speak to the conversations that our working group has had and to that otherwise, thank you.
Great, thank you. Next is Louis Erdachik, Hawaii Disability Rights Center on Zoom. Go ahead. Morning.
Yes, thank you. Thank you. Good morning. Good morning, Chair, Senators. I served on that working group that Shay convened, and it was a very interesting, diverse group of stakeholders. It came out, remember last year we had a proposal to adopt a uniform guardianship law, and it was a massive bill. And so the legislature asked that Shay convene the group, and there was not a lot of agreement on many issues, but everybody did agree on this bill. This is a really good idea for the pilot project. Frankly, Senator Rhodes, I'm surprised that it's not currently in the base budget for the judiciary, because if people are not able to afford these kinds of services, it really should be provided by the court in terms of somebody looking after their best interests and reporting to the court. We all know what an infringement of liberty guardianship is. And so we certainly support the pilot project, and we're hoping that the pilot project will then eventually lead to a request from the judiciary to put it in their base budget. So thank you.
Thank you very much. Next is Audrey Suga Nakagawa for AARP Hawaii. In support, Rachel Liebert Lewis for Easter Seals Hawaii. Also in support, Hawaii Self Advocacy Advisory Council. In support, Elizabeth Kent. In support, and Frank Schultz in support. That's everybody who signed up on HB 648. Does anyone else wish to testify on HB 648? Okay, seeing none. Members, questions? Do have a couple of questions for the Office of Public Guardian. You already touched on it, and I'm just not sure I quite got it. So can you discuss the second amendment that the office requested in its testimony, that a proviso be added to page 3 that will allow the court to order specific professional evaluations? Why would these evaluations not be covered under the wording of professional evaluation of the respondent's alleged impairment?
It's just defining the types of evaluations. Evaluations are testing. So for example, if someone had a medical issue, the doctor would get labs and they would do further testing, and they'll say, well, you know what, that we've done the evaluation. So there's some mix up about evaluations, what constitutes as an evaluation, professional evaluation.
So is this something that's been discussed? Well, maybe I should have you, the working group person. I'm sorry, I've forgotten your name already. Jay. Was this amendment something you guys discussed amongst the working group stakeholders, or do you support this? Do you know if the working group supports this amendment?
So I wasn't aware of this amendment before we came yesterday, so I did try to follow up with some of the members of the working group. I was not able to have like a formal conversation with everybody, so the working group can't take a formal stance at this point. But to speak to it, the conversations that I did have is that there are, under these professional evaluations, there's also the physician's letter. And currently, the way that the law defines the evaluations is that you would be able to do all of these things because it cites the 560 section. So to the conversations I've had, the wording should be okay, but Roland's not wrong that you are clarifying the specific evaluations that can be given, but the language that he's providing his amendment might eliminate a judge from being able to choose to do a physician's letter.
Okay. All right, so if we could we say something like a professional evaluation of the respondent's alleged impairment, including but not limited to the psychological, neurocognitive, or functional evaluation? Would that work?
I think that would suffice.
Okay, why don't we do that, and then we'll move it along and see what we get next. Okay, thanks very much.
Thank you.
Members, other questions?
Yeah.
Okay, thank you. Okay, HB 990, this makes appropriations for claims against the state. First up on 990 is Skylar Cruz, Deputy Attorney General. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, members of the committee. This bill currently contains 21 claims for a total amount of $6,498,867.07. Those claims are described in our attachment A to our testimony. Since the bill was introduced, 2 new claims have been resolved for, a total amount of $70,514. And those claims are described in attachment B. I also want to highlight, as we mentioned in our testimony, that we discovered 2 errors with respect to 2 of the claims on page 2. Those are Billy Peter versus Ann Lopez and Child Evangelism Fellowship versus Hawaii State Department of Education. Those claims were resolved via judgment, not settlement, so we ask that that be amended to reflect that change. Other than that, we stand on our written testimony, and I'm happy to answer any questions.
Great, thank you very much. Next is Department of Transportation in support, Keith Hayashi for the Hawaii State Department of Education in support, and Frank Schultz in support. That's everyone who signed up on HB 990. Would anyone else like to testify on HB 990? Okay, seeing none, members, questions? Seeing none, let's go ahead and move on to the next bill. This is HB 991, clarifies that the Department of the Attorney General may conduct fingerprint-based background checks through the Federal Bureau of Investigation on Contractors and Contractors' Employees. First up on 991 is Philip Higdon, Hawaii Criminal Data Justice Center. Good morning.
Yes, sir. Good morning, Chair, Vice Chair, and committee members. My name is Phil Higdon, Administrator for the Hawaii Criminal Justice Data Center. We've submitted written testimony in support of this bill. I'm here to answer any questions. I think it's important to know right now that the individuals that have need this information only are able to, for conviction information. So they need fingerprinting for national arrest information as well.
Okay.
Yeah.
Thank you.
Thank you.
Next we have Frank Schultz in support, and that's everybody who signed up on HB 991. Does anyone else wish to testify on HB 991? Seeing none, members, questions? Okay, moving on to HB 998. This clarifies that the omission of certain information or any error in a citation that does not constitute grounds for dismissal of a charge or for reversal of a conviction if the omission or error did not prejudice the defendant. First up on 998 is Deputy Attorney Mark Tom. Morning.
Morning. Good morning, Chair, Vice Chair, members of the committee, Deputy Attorney General Mark Tom for the department. Department provides testimony in strong support of House Bill 998. Essentially in 8036, that kind of covers a number of things. It allows for officers, law enforcement to issue a citation in lieu of an arrest, but it also allows for the guidelines for certain information that should be in the citation. Some of that information, like social security number, is very impractical and for some individuals impossible to put into that citation. This bill would just ensure that when that information is not able to be obtained, that the remedy is not dismissal of the charge or reversal of a conviction, as long, again, as the bill states, does not prejudice the defendant with that information. So I will be here for any questions. Thank you.
Great, thank you. Next up is Director Lambert for Department of Law Enforcement and Support. Robert Cavaco for State of Hawaii Organization of Police Officers. Also in support, Frank Schultz in opposition. That's everybody who signed up for HB 998. Does anyone else wish to testify on HB 998? Sure, come on up, Mr. Hugo. Good morning.
Good morning, Chair Rhodes, Vice Chair Gabbard, and members of the committee. I'm Daniel Hugo for the Honolulu Prosecutor's Office. If this bill does not pass, and it's based on a recent interpretation in 2 cases from Honolulu District Court, this bill does not pass. Officers will not have the option to issue a citation if the person does not have a social security number or an address. Pretty common situation. Then they have 3 options. They can do a summons, they can do a warrant, or they can do a warrantless arrest. A summons and a warrant mean that they have to go and find the person again. So the likely outcome of this is more warrantless arrests of people who could have been issued a citation for no other reason than that they lack an address or a social security number. And we don't think that's a good outcome. I'm happy to answer any questions. Thank you.
Great, thank you very much. Would anyone else like to testify on HB 998? Seeing none, members, questions? For the AG, for Mr. Tom, if you don't mind. Is the AG's Department of the Attorney General done a review of any constitutional concerns if the information is not provided or is incorrect as proposed by the bill? So if the person gives incorrect information or just won't provide it, is there a constitutional problem of any kind?
Nothing, no constitution that we're aware of. You mean if we don't have the information and they still issue the citation, or how is that?
Or if the person,
what type of situation?
If the person refuses to provide the information, or it's incorrect for some reason, or they lie to you, or they just get it wrong.
I think the law enforcement tries to confirm that information. Like we said in the guidelines, some of it is very factual to the offense, which those are the things that you want to make sure that it's not that it could prejudice the defendant if that stuff is not in there. But some of the information, like social security number, probably won't in most cases prejudice the defendant in any way. It's more to identify that defendant properly, but not that we're aware of any constitutional issues. Okay, so I mean, sort of a follow-up on that, does the new language to be added about the omission or error of the information not being prejudicial? I mean, is that enough? Is that enough of a due process protection, or enough of
of a guarantee that we're not going to charge people that shouldn't be charged
Yes, that language is utilized in the HRS, in another statute. So
already.
yeah, it's already utilized.
is it?
That's,
Where is it now?
that is, I can pull that and provide that for the court, but that language is actually borrowed, from the HRS, to provide a remedy. And so this is not like new crafted language that doesn't exist already.
Okay. So is the phrase "if available" sufficient to cover all situations where the person does not or cannot provide their current address or the last four digits of their phone number of their social security number? I mean, if they refuse, or are the amendments really is that amendment really necessary, since the amended statute later addresses errors and omissions?
I think sometimes for like the current address, if available, sometimes they don't have an address. They might be, if somebody is maybe homeless or can't provide one, that just provides the flexibility that the officer has done their due diligence to collect all the information that they can collect for the citation to make sure that that's properly filled out. But if there is nothing, that they are allowed that flexibility, that it's just if it's available to that officer at the time.
Okay. So what happens if a police officer cites a person and, they're incoherent, suffering from a mental illness, or they don't speak English well enough to convey the information? What happens? Can you not write a citation in that situation?
I guess it really depends on the situation itself. If they're not able to get that information from the individual, they're having a mental health issue, they might take them into custody, maybe get them assistance at a hospital or whatnot. But in terms of a citation itself, officers will work with the individual and try to get all that information.
But if they can't get it, then what happens?
If they cannot get that information, they might be inclined to arrest at that point to make sure that they can confirm the identity. If let's say the individual is giving a name that they cannot confirm the address or social security number and determine that that's the person that they're issuing the citation to, they might be inclined at that point to arrest.
Okay. All right. Thank you. Other questions, members? Okay, thanks very much. We'll go ahead and move on to HB 1174 relating to procedure for payment under protest lawsuits. Allows for the interest earned on payments under protest and the litigated claims fund to be paid in non-taxation cases if the claimant prevails. First up on 1174 is Tom Yamachika for the Tax Foundation on Zoom, maybe.
Not available on Zoom, Chair.
With comments, Frank Schultz in support. That's everybody who signed up on HB 1174. Does anyone else wish to testify on HB 1174? Seeing none, no one to ask questions of members. I think I'm ready to roll into decision making. There's any objections? Okay. First up on this agenda is HB 399. This establishes one additional district court judgeship in the First Circuit. Recommendation, because there's no appropriation, this is just establishing the position, is to go ahead and pass it with an effective upon approval date. Questions or concerns? If not, Vice Chair Gabbard.
On HB 399 HD1, recommendations to pass with amendments. Chair Rhodes.
Aye.
Vice Chair Rhodes, aye. Senator Chang.
Aye.
Senator San Buenaventura.
Aye.
Senator Awa.
No.
Measure passes.
Thank you. Next up is HB 560. This appropriates funds to the judiciary for services contracted with community-based organizations that deliver essential services. The recommendation here is to go ahead and move it ahead, but with a different effective date. So April 23, 2057. Questions or concerns? If not, Senator Gabbard.
On HB 560 HD1, recommendations to pass with amendments. Are there any no votes or reservations? Hearing none, the measure passes.
Thank you. Next up is HB 648, establishes a 2-year pilot program in the probate and family court of the First Circuit to fund certain guardianship and conservatorship related court resources in situations where the respondent cannot pay. Recommendation here is to go ahead and pass with some amendments. We'll go ahead and accept the amendments from the Office of Public Guardian. The first one, so this makes a clarification in the preamble at the bottom of page 1 through the top of page 2 to replace the phrase physician's letters and report, also statutorily referred to as professional evaluation with. Okay, now I'm not sure that's right. I was going to change the Okay, I got it. Okay. So we'll go ahead and accept that, but we'll conform it with the other amendment that we're going to make, which was also suggested, or at least the base of it was suggested by the Office of Public Guardianship. So on page 3, line 17, at the end of paragraph 3, insert a proviso that allows the court to order specific professional evaluations. So we'll say instead that the court may order the professional evaluations, including but not limited to the psychological evaluations, neurocognitive, or functional evaluations that the public guardian the Office of Public Guardian suggested. And we'll put a different bad date on it, April 23, 2057. Questions or concerns? If not, Senator Gabbard.
Recommendations to pass HB 648, HD 1 with amendments. Any no votes or reservations? Hearing none, the measure is adopted.
Thank you. Next up is HB 990. This makes appropriations for claims against the state. Recommendations to pass with amendments. Go ahead and put a different bad date on it, April 23, 2057. We'll add the additional claims that the AG requested to the tune of $70,514. We'll also accept the AG's requested amendment to change the description of 2 of the claims from settlement to judgment. Questions or concerns? If not, Senator Gabbard.
Recommendation on HB 990, HD 2 is to pass with amendments. Any no votes or reservations?
No.
No vote for Senator Waugh. The measure is adopted.
Thanks very much. Next up is HB 991. This clarifies the Department of the Attorney General may conduct fingerprint-based background checks through the Federal Bureau of Investigations. Recommendations to pass with amendments to reflect the changes that we made to the companion bill SB 1310. So the language that we would put in would be throughout the bill would be contractor, contractor's employee, or subcontractor to, like I said, to reflect what we did in the companion bill. Questions or concerns? If not, Senator Gabbard.
On HB 991, HD 1, recommendations to pass with amendments. Any no votes or reservations?
No.
No vote for Senator Waugh. The measure is adopted.
Thanks. Next up is relating to contents of citations. This is HB 998, clarifies that the omission of certain information or any error in a citation does not constitute grounds for dismissal if the omission or error does not prejudice the defendant. The recommendation here is to go ahead and pass as is. Questions or concerns?
Question.
Sure.
Minor error. What constitutes as minor?
Need to go to law school. What are the dictionary definition of minor? So small or insignificant.
I would just for the record, I'm a stickler, right? As you are, Mike, with writing, and I think they should get it correct. Whether it's grammar or whatever that minor error might be, we should hold them a little accountable. So we know them out better. So.
Okay, thank you. Any other questions or concerns?
My understanding in HB 998, it's not all minor errors. I believe the concern in 998 was the current address, if available, and the social security number, if available. Those are the only errors that we are that we're referring to, and not a whole slew of minor errors.
There wasn't
And unless chair is amending it to include.
No, I'm not amending it at all, or not
Okay.
not suggesting amending it, but the omission or error can't prejudice the defendant either. So even
Right,
if
I
it's a minor
understand that,
error,
but those are the 2 minor errors we're
Yeah.
referring to.
I think that's correct.
So if
Only
with those, yes, with those clarifications, then I will be voting yes, because otherwise I agree with Senator Obama. Yeah, right there, see.
Other comments or concerns? If not, Senator Gabbard.
Recommendation on HB 998 is to pass as is. Any no votes or reservations?
No.
No for Senator Waugh. The measure is adopted.
Thank you. Moving on to HB 1174. This allows for the interest earned on payments under protest and the litigated claims fund to be paid in non-taxation cases. If the claimant prevails, establish a procedure for the disposition of monies and refiling of actions when a payment under protest suit is filed prematurely. I think it's ready to go. So recommendation is to pass it with upon approval effective date. Questions or concerns? If not, Senator Gabbard.
Recommendations to pass with an amendment. Any no votes or reservations? Hearing none, the measure passes.
All right, that brings us to the end of our agenda. Thank you, everyone, for being here. We're adjourned.